Mr. Knox.
Good morning, my lords, my lady. I would just like first to deal or return to the point about was the jury quorate, if I can put it that way. Was it quorate? Was there a quorate jury? Nothing to do with unfairness of the trial as such, purely were there sufficient members on that jury when the verdict was reached on a proper view of what the Juries Act requires. And my submission is this. On a proper construction of the Jury Act, there is no automatic disqualification of a juror just because he is said by another to have been acting improperly in the performance of his duties. The discharge, though, it is only when he is actually discharged from the jury that the number of jurors is reduced. And, my lords, overnight, my lady, overnight, Mr. Turnbull and I dug up the entire Juries Act, because in my submission one does need to see the structure of it. When I say entire Juries Act, it's not very big. It goes back to 1892. But in my submission, when one looks at the structure of the Juries Act and what it is talking about, it is plain, in very summary terms, that there is a public duty on people to act as jurors. If you qualify to be a juror, then you must act as a juror, and it is only when you are discharged that you cease to be. There are certain requirements for qualification, such as, for instance, mental capacity and so forth. But my short point is once you're on that jury, you are one of their number until you are actually discharged. But I can deal with it quite briefly, and we sent it over this morning. It goes back to, the Act goes back, I think, to 1892. If you look at, I'm not quite sure what numbering you're adopting, but if you look at, as it were, the opening page of the Act, this Act may be cited as the Jury Act, you'll see it goes back to, it says, 1962 at the top, and indeed, but that's the edition of laws, but you'll see under the heading, the Jury Act, 7th of July, 1898.
Sorry, Mr. Knox, I've got a problem. I can't open the file. Bear with me for a moment.
This is the supplementary Jury Act
Yes.
The one was sent
document.
this morning.
Yes, it would have been sent this morning.
Yes.
I hope it is translatable.
Yeah, I'll try and type it.
Just sent it by email.
It's also on your shared drive.
Yes, it's the shared drive, but I can't
I've
get
sent
into
it by email.
It opens on the email, I think.
I've got it on the no. Yes, I've got it on the email. Thank you very much. Sorry.
You'll see it's passed originally in 1898. This is essentially, I suspect, we haven't had time to do a full research. Essentially, in the Caribbean countries, there was often codification of the common law in the 19th century, and we rather suspect this goes back to a sort of codification translated to Jamaica. But you'll see, first of all, Section 2, qualification of jurors, and you'll see there's a requirement in Section 2.1 for any person of certain age and so forth to be qualified and liable to serve on juries. You'll see certain exceptions, one of which is in 2B, sub 2.2b, cannot speak, read and write English. And others, D, for instance, you've been convicted of treason or another serious offence, then you're not qualified. And then subsection 5, save as provided by or pursuant to this section, and subject to section 18, no person qualified to serve shall be exempt from jury service. And then section 6, no person whose name is on the jury list, I'll come to that in a moment, as a juror shall be entitled to be excused from attendance at court on the ground of any disqualification or exemption other than illness not claimed by him at or before the final settlement of the list. But a judge, registrar of the Supreme Court and so forth may excuse any person if satisfied that the person is disqualified or entitled to exemption, hardship in case of employment, or such person, for the reasons which appear sufficient to the judge and so forth, should be excused. And that's why I say this is essentially a public duty. Then section 7, you have the provision as to how jury lists are made up. I don't propose to read that out, but there's a provision for making up of jury lists. and Section 8 gives further details as to how the jury list is to be drawn up, essentially by justices. And then Section 10, it shall be lawful for the justices at such sessions to strike out of such lists the names of all persons shown to their satisfaction to be not qualified or not liable to serve on juries, or to be dead, or disabled by mental capacity, deafness, blindness, or other permanent infirmity. So this is the way, as it were, you are removed from a list. And then B, to add to such lists the names of any other persons, and then C, to correct errors. And then moving over to Section 13, where the list has been settled, the justices shall certify that the list is, to the best of their knowledge, a true and proper list, and so forth. And that is the list which is to be used, from which jurors are subsequently selected. One then goes to, I think, provisions we already have, Section 31, on trials on indictment for treason or murder, committed in certain circumstances, and that's essentially capital murder. 12 jurors shall form the array on trials on indictment before the circuit court other than for an offence in 1, 7 shall form the array, and then 3, where... forgive me, my lord.
Can I just ask, is ours a murder falling within either of those two categories?
No, I don't think it is, because it's, I think, just dropping down, it is in, whether it's 44, Section 44, I have a feeling.
Yes, well, if that is with a view to Section 44, I was asking the question.
Yes, yes. we're in Section 44.
Would we have been in 31 1B but for the discharge of one juror? Or is it not a murder within?
I have a feeling, I can double check this. In Jamaica, they've got a capital. They essentially have capital murder, for killing a policeman in the execution of his duty, and for that you need 12. That's what I understand this to be saying.
I see.
You can't go below 12 for that, but we're not in that category. So, 31, 12 jurors shall form the array, and then. Subsection 3, where in the course of a criminal trial any member of the jury dies or is discharged by the court through illness or other sufficient cause, the jury shall nevertheless, so long as, my lords, you can imagine I emphasise this, the number of its members is not reduced by more than one, be considered as remaining properly constituted for all the purposes of the trial, and the trial shall proceed and a verdict may be given accordingly. And then subsection 4, where one juror has died or been discharged, the verdict of 11 jurors in a trial for treason or murder referred to in 1B, or of 6 jurors otherwise, shall be deemed to be a unanimous verdict.
So ours would be within the ambit of the provision about 6 jurors.
I don't think we're down to 6 jurors, no. My lord,
well, we're not in the... You just told us ours isn't a trial for treason or murder referred to in subsection 1B.
My lord, if I can just double check, that's my understanding. Certainly my understanding is that it may be, if I can double check this, it may be we are in fact in 31, so that you can go down to 11. That certainly seems to be the assumption on which everyone proceeded.
Well, I don't know if they did, because when you get to 44,
yes,
I think the implication of 44 is that you need a unanimous verdict to convict of a murder falling within the categories described in 31 1B.
Well, can I just take instructions from those behind me, because that explains it. What we're looking at here is, if you look at section 31, it's an amendment made in 2015.
Yep.
That is why there's confusion. I do apologise. But the proper 2010 Juries Act is already in the bundle. In other words, what I've produced today in this section is a 2015 amendment, which I think well,
Right.
which would post-date the trial.
Can you show us in the 2010 version?
Yes, that would be, I think, I think I'm right in saying volume 1. I hope I'm right in saying volume 1 of the...
Same amended.
Yeah, we've got section 31. We don't have section 44. But it's
also got the 2015 amended.
no, this the version we've got in bundle number 11 on is again the 2015 as amended in 2015. That's page 6803.
My Lord, I do apologise.
I appreciate you don't bear sole responsibility for this, Mr. Knox, by any means, but it's quite important that we actually have the legislation that was enforced at the time of the trial.
My Lord, absolutely.
Yeah.
My Lord, can I say one of the difficulties? This wasn't a point, of course, that was raised in the appellant's grounds and so forth. So it has been a bit of a rush, and I do apologise. It does look as if
we don't need to be rushed. We can adjourn for some minutes if that's going to give you time to get hold of a copy of the correct version of the Jury Act.
as in force at that time. It's not always that easy from my experience. One has to dig back a bit. But can I just say this, certainly for the time being, the point I'm making, I'm assuming, as everyone has assumed, that a jury of 11 was a sufficient number, but it couldn't go below 11. That appears to have been common ground throughout the trial, and indeed in the Court of Appeal, as I understand it. So that's the premise. You can't go below 11. The point I'm on, in one sense, is not whether or not you can go below 11, but what is the nature of a jury? And the nature of a jury, in my submission, is simply there are 11 members on it. And if there are 11 members on it, you've got a quorum. Even if, for some reason, one or other of the jurors is not is acting improperly, or there's reason to suppose he's acting improperly. As long as he's on the jury, he is one of their number. And it's only when he's discharged that the jury number is reduced. That is the point I'm seeking to make, my lords. And I do accept, my lords, that obviously it would be important to get the right version for you, my lords. If we could, I'm not sure we could do it within a matter of minutes, just from experience, but if we could do it as soon as practicable, and get over to you the relevant section with, if appropriate, a very short note about what it comes to, that might be a better way of dealing with it. Yep. But for the moment, my lords, I'm just making the point, there was a quorum. And the reason I say that is because jury service is a public duty. You can't just get out of it. And once you are in the charge, if I can put it this way, of the jury, it's the jury who has to deal with you until the judge says, until the judge, quote, discharges that particular juror.
31.
My lords, I've just received a note saying the Deputy DPP has sent the 2010 Act. I won't have received it myself, but my lord, perhaps I could just come back to that in a moment rather than take time trying to find it myself. My lords, yesterday one of the questions was put, well, what about mental illness? Now, one can see that if someone becomes mentally incapable in the course of the trial, let us say, on day 7 he is simply incapable, well, my lords, in my submission he is still strictly on the jury unless and until he is removed, but in circumstances like that, the judge in my submission would have no choice because that juror would be incapable, simply incapable of performing his oath. And there's a difference in my submission between a juror being incapable of performing his oath and a juror who is capable of performing it, but who is, for one reason or another, bent on not doing so. And in the latter case, I submit, he still counts, and the judge is still entitled in principle to say, I'm going to carry on and I'm not going to release you from your oath. So that's the first point I wanted to make on the quorum. The other point I was asked yesterday, could a court review a decision made by the jury after it has made it to find out whether or not it was in fact, there was in fact, let us say, a crooked juror on it, with a view then to that conviction being set aside? And my lords, my lady, the answer to that is yes, and that's exactly was the issue in the case called Merzer, which is in the bundles at 7490. And that was a case where after the event, one of the jurors, the disgruntled juror who had wanted an acquittal, wrote, I think to the court or to the judge, saying, I'm very unhappy about this, because I think the other jurors were racially motivated to produce a conviction. And the matter went up to the Supreme Court. And of course, one question was whether, given the Contempt of Court Act, 1981 in the UK, the court could actually investigate that allegation. They held that they could, on the footing that the Contempt of Court Act wasn't intended to prevent the court from making such inquiries with a view to an appeal. And the common law position was, they held by implication, that of course the court can, with a view to an appeal, make such an investigation if necessary. And on the facts of the case, the Supreme Court held, I think it was the House of Lords held, there was no need, there was no requirement to look into the point. But one can pick the point up, it's at 7490, at paras 9 to 10, that's where the case starts, at 7504. And this is in the speech of Lord Steyne, 7504. Undoubtedly, there must be a general rule: deliberations of the jury must remain secret, and they refer to Gregory, the ECHR case, which accepted that. And then, moreover, there's a strong rebuttable presumption that the jury was impartial, and that is how the matter is dealt with there. And they went on at the end, or rather Lord Steyne giving, I think, the speech with which others agreed, at para 32.
We must be a little bit careful with Lord Steyne because he dissented.
I have a feeling he may have dissented in the result. I'm not sure if he was dissenting in the...
Yeah, but I haven't read this for years, so I can't recollect, but I'm just saying we need to be a little bit cautious.
Yes. I'm not sure he dissented on this point, but if one looks at the head note, he does. He is, as it were, agreeing that the court can look at the position after the event.
Yep.
And one gets that from the head note, but I was also taking to where Lord Steyne.
Where were we going after page 7504?
I was going to go to 7512 at 32, where Lord Steyne says, well, on the facts, he wasn't satisfied that the complaining juror after the event was giving an entirely accurate account.
Which is paragraph?
32.
Thank you.
But as I understand it, you're saying this case would fall within what's called the only exception, paragraph 11.
Yes.
Yeah.
So the secrecy rule is the prevailing rule, but there can be exceptions. And that's the main holding. I'm just looking at 7490. So, my Lord, that's what I say. So it is in theory possible. It would in theory be possible for a juror after the event who's kept, or for it to be discovered after the event, that a juror has been bribed, he's kept it to himself, and for the court then to investigate. But in my submission, in those circumstances, the court would still say, even though the juror had been bribed, let us say, the jury was quorate.
Is the ratio of Mirza at paragraph 94 in Lord Hope's speech, on page 7527, paragraph 94 onwards, which makes clear there is a prohibition? It's only where, in effect, some extraneous occurrence has occurred that means effectively the jury didn't deliberate. They used a Ouija board or something of that kind.
94, 96, yes.
Yeah.
95. Of course, there's no doubt about the general rule. My Lord, that's what I have to say about the quorate point. Was the jury quorate? My answer is yes. The next question is, was the judge bound to discharge the jury in any event because the risk of prejudice or bias was irremediable? Should he have said at that point, when the complaint is made, should he have simply said, well, we can't carry on, full stop, because of the risk of prejudice to the defendant? So my submission, no. First, there's the point I made yesterday. It cannot be the case that an accused can engineer the automatic end of a trial by his own misbehaviour, tampering with the jury. And likewise, I submit that cannot be the case in the event of a juror who, let us say, he hasn't been contacted by the defendant, but for whatever reason, he is acting in the interests of the accused and offering bribes. It cannot be the case that a trial be brought to an end so automatically in those circumstances. And in my submission, were there to be such a rule, this is a common law matter, that would bring the system, the whole legal system and the jury system into disrepute and make the administration of a jury trial almost unworkable. Second, on the facts...
Well, why do you say that? Because in normal circumstances, if this came to light, that particular juror would be discharged.
I agree with that, normally.
So the whole system wouldn't come to a halt?
In circumstances such as this. I agree with that, because you could discharge a juror, but in circumstances such as this, it would bring automatic. If my learned friend's right, there's an automatic. It just comes to an end, full stop. I submit that cannot be right. There is still a power in the court, as long as a fair trial can be ensured. There's still a power in the court to allow the trial to go ahead. And in my submission, the next question then is, well, did the judge exercise, or can it be said the judge exercised his discretion wrongly and perversely in allowing the trial to go ahead? That is the correct question, focusing on the position as it was before the trial judge when the problem came. And in my submission, the trial judge, it would be wrong to interfere with the trial judge's exercise of discretion for the following reasons. First, as things stood, it was a mere allegation, no doubt one which appeared to be supported by strong evidence, but it would not be practicable at that point to carry out an investigation of the corrupt juror himself. That couldn't seriously have been done, and what is more, my Lord, I might add, although he was found guilty of attempting to pervert the course of justice, he did in fact plead not guilty. One just wonders, well, what in real life? What benefit would that have done? How could the judge have taken matters further? He had it on the word of the forewoman that she had told the jurors that they weren't to take any notice of this, and in my submission, that was good enough. What was to be gained by the judge asking each and every juror what their position was? Secondly, in my submission, the judge was entitled to take into account the view expressed by the forewoman that none of the 10 jurors had accepted the bribe. That's an important point. He's entitled to take that into account and say that, well, that sounds true to me, and that she, the forewoman, had told the others that they must abide by their oath. It's obvious that the judge was impressed by the forewoman, and he will have seen her, and he will have to form a judgment as to whether she's a trustworthy person. And he's entitled, in my submission, to take that into account. Third, he was entitled to take into account, A, his own directions so far, and I'll come to those in a moment, B, his assessment of the jurors over the 56 days of trial so far, especially this, my lord. It is evident they had acted on his repeated warnings not to talk to anyone, despite the obvious temptation of doing so in such a high-profile trial. And C, he was entitled to take into account that he could give a further direction that could be given to remedy any prejudice to the accused. Now, I'll come to that direction, if I may, in a moment, but just before he goes back into court, he's entitled to say to himself, it is proper for me to carry on with this trial, because I can ensure that a fair trial will happen, bearing in mind everything that's happened in the case. Thirdly, I emphasise this point. The Court of Appeal, who have a good knowledge of the local circumstances, upheld the way the judge dealt with that. And that you see at E5869, paragraphs E5869, my lord, yes. 5869, paragraphs 237 to 238. And then also at 240 to 241. To 238, 240 to 241.
I mean, the paragraph, the second sentence on page 5869.
Yes.
That approach, on the face of it, looks somewhat problematic, I would suggest. That we don't want to investigate much further because the likelihood is we're going to have to discharge the jury.
Well, my lord, one has to see that in context. He's saying there was nothing to be gained and a great deal that we've lost the possibility of having to discharge by questioning the accused juror. So it's not just saying, the Court of Appeal is saying what was to be gained by questioning the accused juror. And in my submission, that was a perfectly proper approach. I mean, one does ask, what was to be gained by...
But it's an acknowledgement that that juror was not going to abide by his oath, isn't it?
Oath. Well, it's an acknowledgement that he may well not abide by his oath. That is right. I cannot deny that there was obviously a risk, bearing in mind that...
Well, more than a risk, it was...
A likelihood, maybe. So far as one could tell. One only has an allegation. But I come back to the point I made yesterday.
Well, if it was just a risk, then he would have investigated and impressed upon the juror the importance of not being affected by extraneous considerations.
I can see that. But even if one allows that, you have my submission yesterday. If the risk is just that one, or probability that just that one juror is not going to perform his duty, that in my submission is not a reason for discharging the entire jury if the prosecution, who are affected by that bias, says carry on anyway. And that you might say is a pragmatic point, but in my submission that is a perfectly proper approach for the court to take. If if it is, I mean, it wouldn't be right the other way round. If there was a juror who's biased against the defence, that might all be very different indeed. But here we are talking about the state who's bringing the charge in the public interest, who knows there is a problem with one juror. But one juror is bent against the prosecution, come what may. Let us assume.
But the real problem which we're facing isn't it that there was a risk that the whole of the rest of the jury were biased against the defence?
My Lord, I accept that's a different risk, if I may, for the moment. That is a different risk. But just as far as questioning the individual bad juror, my Lord, and that was the point which this particular paragraph is on, I submit that there was nothing to be gained. There was indeed. What's he going to do? He's just going to deny it, probably.
Yes, but it is really the point I think that Lord Burrows was making, that if you read on, saying a great deal would have been lost by questioning the accused juror. And what would have been lost would have been the trial, because if the accused juror had admitted the conduct alleged, then not only he but the entire jury would have had to be discharged.
Well, my lords, I submit he wouldn't necessarily have to discharge the jury, even if, let us say, the individual juror had said, "Oh, I own up. I did try to bribe them." My lords, it all goes back to the single point. There's a different point that Lord Briggs makes, which is about the introduction of the rest of the jury, but it's just this one point. Supposing the judge is entirely satisfied that 10 jurors can perform their duty properly, I'm sure they're able to do it, but he knows that one is very unlikely to do so. Supposing that is the position, the question is, as a matter of law, must he discharge the jury? That is the question. And if the answer to that is yes, he must, then I accept I'm in difficulties. If the answer is no, he doesn't have to, if the prosecution is content to take the risk that this one juror is just going to vote against the prosecution, come what may, in my submission, he's entitled to do that.
I think the answer that would normally be given is you must discharge that juror.
If of course, I agree with that. In normal circumstances.
So if we assume that the legal position is you must discharge that juror, what is then your submission?
Well, in my submission, if you absolutely must, in all circumstances, even in a case such as this, where you've got right to the end of the trial, you can have a 10-1 verdict, and so forth. If you must, then, my lords, I accept. Then what has happened is that the verdict that was given by 10 people who were entitled to be on the board of panel, and one person who wasn't. And then the consequence of that would be, I suppose, that you do not have a quorate verdict.
The implication of your submission seems to be that in a criminal trial, and you could hardly have a more serious trial than this, where you have 5 people accused of murder, clearly there's a public interest in a true verdict being returned. The implication of what you're saying seems to be that the judge really has no responsibility in that regard. He's entitled, if the prosecution are willing to run the risk of the jury being nobbled by the corrupt member of the jury, that's a matter for them, and he can go along with that.
My lords, he has to be satisfied that the other 10 won't be nobbled, or it's very unlikely they'll be nobbled. I'd accept that. But if his thinking is, and I submit it was likely to have been this, I've got one bad juror here, I've got good reason to suppose the other 10 will behave properly. That means there will be, the jury will be quorate at 11. In my submission, he is entitled, he is not bound to say, I've got to stop the trial now. He has a power to allow the trial to go ahead. That is, and my lords, I accept that is the kernel of my submission. It has to be one which he exercises not entirely unreasonably in all the circumstances of the case. That is why I'm making the submissions I have been.
If it were the case that the same rules applied in Jamaica as apply in England and Wales, that is, you could have had a jury of 10, What would you then say?
My lord, I think I'd be bound to accept that the judge would have said, let's go down to 10. He probably would, in those circumstances, have said, balancing...
So the problem that you're faced is a system that doesn't allow a jury of 10.
That's exactly the problem. The whole problem.
An unfair trial, it might be put against you, is allowed because the rules don't allow a jury to go around to 10. Is that right?
No. I'm not saying that. I'm far from saying that. As long as the trial is fair, overall. I haven't come to my point about the fairness of the trial, but as long as the judge is satisfied that a fair verdict can be returned, even though one juror appears to be bent on assisting the defence, the judge can say that of the lesser of two evils is that the trial goes ahead, the administration of justice is served by the trial going ahead, and there is no common law rule that requires me to stop the trial.
The corrupt juror might be critical, his vote might be critical to whether there was a majority or not.
It might be. But in those circumstances, that is a risk that the prosecution takes.
Well, that's the point. You see, that's the point I'm jibbing at, really.
Yes.
The idea that responsibility for the administration of justice in the public interest is the responsibility of the prosecutor and can effectively be waived, if you like, by the prosecutor, rather than being the responsibility of the court.
Yes, I do accept that, but my lord, it is still the responsibility of the court. If the court is satisfied...
But we see the problem. If you're presiding in a criminal trial where a majority verdict can be returned, and you know that one of the members of the jury, or you have good reason to suspect that one of the members of the jury may be corrupt, for all you know, the way he votes in the jury room could be critical to the verdict that's returned, and could result in a wrongful acquittal, for example.
My lord, again, I come back to my point. The judge is entitled to weigh up all the different evils. I mean, the real problem is that the judge was caught between two evil solutions.
Yes, I've got the greatest sympathy for the judge. And I mean, in this country, we would think twice about rerunning a 67-day trial. But in a country like Jamaica, the expense involved in this, apart from anything else, is enormous.
But, my lord, my submission is this: as long as the prosecution is acting responsibly, and as long as the judge is acting responsibly and reasonably, rationally in making these decisions, and as long as they are satisfied that overall there can be, not necessarily that there will be, but there can be a fair verdict, if there can be, then in my submission the lesser of two evils is to go ahead and get that fair verdict, rather than simply say trial off, no verdict, which in real life may well mean no trial whatsoever. And that is why I say one must look. It's not just a matter of sympathy for the judge, it's what is the responsible, forgive my putting it this way, the responsible response to this very, very difficult situation. Which is the lesser of two evils? And my submission is the lesser is to go ahead in the hope that there can be a fair verdict. You may well land up with an unfair acquittal. That is one risk you take. But it is better to take the chance of getting a fair verdict than to abandon that altogether.
That fair verdict would be reached in circumstances where the allegedly corrupt juror would not only have a vote, but he'd have the opportunity to influence the other members of the jury.
Well, he might still seek to influence the other members of the jury, but he wouldn't. Sorry?
In deliberation.
In deliberation. He can still say what he likes in deliberation. He can still draw attention to a good point, let us say. That can still happen. He's not prevented from doing so. He may well be able to persuade one of the other jurors, not by offering money.
Well, by offering money.
No.
But he may.
No, he may be able to persuade one of the other jurors in deliberation. Look, forget about my bribe. These people are innocent because of point X. He's still entitled to do that.
Well, he's entitled to do that, but he's not entitled to persuade them by offering them bribes.
Certainly
That is an ongoing risk.
That is, my lady, I accept that is an ongoing risk.
Yeah.
That must be right, is a risk. He will try again.
Yeah.
I mean, you might think it's a bit unlikely if the matter's been reported to the judge, actually, but there's a possible risk. Let us say there's a possible risk. My lady, even in those circumstances, if that is a risk which the prosecution is prepared to take in order to achieve a verdict, that is the lesser of two evils, and if both the judge and the prosecution think that is a proper way of proceeding, they can. That is my fundamental point. And one of the problems with jury trials is one is trying to create a system of perfection, in one sense. Of course this is not perfect. No one would begin to say it's perfect. But is it, in fact, the pragmatic way forward, which did, in the event, secure a fair verdict? That is not.
But the defendant's counsel didn't accede to this way of proceeding. They continued to raise Well, on the face of it, it looks as if they were objecting.
They did. There's no doubt about that. But they were objecting for different. They weren't objecting on the quorum point, but they were objecting because of the way it's put, I think, by one of them is the overcompensation point. I'm concerned about it, and that's a fair point.
Yeah.
I'm not saying it's a bad point, but in my submission, it's not a conclusive point. The judge is entitled to say, well, I'm still prepared to put this matter to the jury because of the various points I'm going to come to later, because the strength of the case, I've been assured that I will give another direction. I have already given directions about not being persuaded by extraneous matters. The judge, in my submission, and this is, in a sense, the heart of the case, was he bound to stop it? My answer is no, he was not bound to stop it, for the reasons I've given. And I do submit, I take my Lord's point about the Court of Appeal's judgment, but I do submit this is important to bear in mind what the Court of Appeal had to say about this matter. They have familiarity with how juries work, how the system works, and it's their primary responsibility to ensure the criminal system works properly. You are operating as a second review court. This is a point to be made again and again. And I do submit great respect should be given to the Court of Appeal's assessment on this point.
Well, it will be.
But so, my Lord, you have my point on that. So I say there was no error of law in what the judge did. That's what it boils down to. He acted within his discretion. It was not an unreasonable decision to make, given the extremely difficult circumstances in which he found himself, and the possibility there could still be a fair verdict. That's the point. My Lord, can I just turn to the judge's directions? Because it's important, it ties in with the previous point. I've already given you references to some directions before. Can I also ask you to go, please, to E4723 to 4, which is what he says to the jury right at the beginning, which is a resounding direction in my submission. E4723. 4723.
4273 or
4723.
This is right at the start, is it?
Yes, right at the start.
Start of his summing up.
Start of his summing up, yes. And it continues to 4724.
Now this was, at this stage, by the judge in ignorance of the nobbling.
Yes. And I don't propose to read that. If you could just read those 2 pages, continuing to the top of 4725. And I should actually ask you to continue to near the foot of 4725, actually. If I may. Now, if I can answer Lord Burroughs' point he put to me yesterday about more pointed summings up in other cases, if this had followed the incident about the bribing juror, one would say it covers the points. Ignore all prejudice. In particular, each of you, right at the beginning, each of you took an oath or affirmation. You will recall that. This is of great significance. I want you to hold to that. The oath is of great significance, not to be treated lightly. The essence of what you swore to do or affirmed is that you would decide the case based on the evidence, and then repeatedly he goes on later. He says, I've been boring you all the time about my constant reminders, and they're all over the place. I tell you again, because it was of tremendous importance and remains such. And then 4725, I implore you because of the oath you took, serious and responsible function that you have. You cannot bring external considerations into it. Now, my submission is this. He doesn't repeat this after the incident, but he said it right at the beginning. And in my submission, one has to act on the premise that the jurors haven't forgotten all about this, especially because it's something he's been, if I may put it colloquially, he's been banging on about all the time, the importance of the oath and the seriousness of the task they're employed on.
Can you remind me how long the summing up lasted?
I think it begins on the 6th of March. You can see that at 4722.
Ends on the 13th, I think.
Yes, I think there are breaks. I have a feeling it may have been 3 days altogether, but I will be corrected if it's 4 days.
Thank you.
I think there may have been, but anyway, we know the gap is ultimately 6th of March to the 13th, I think
so.
Which is perhaps the more important point.
Yeah.
But in my submission, they won't have forgotten all this. Can I also, while I'm on this point, at 4738, a little bit further on, is the point about prejudice. And this, 4738 to 4741, he goes on about prejudice. Ignore all prejudice. Just look at the evidence. Don't speculate. And it goes on to 4741. In 4741, halfway down the page. If I can just ask you again to read that yourselves. In particular, the first half of 4741. Again, I implore you not to allow feelings of sympathy or prejudice to influence you, cause you to ground your verdict. There's no room for a verdict which has its genesis in sympathy or prejudice. Your verdict must be arrived at on the basis of the evidence and on that basis alone. All this is coming quite early on in the summing up, but it's absolutely emphatic. And just while I'm on the summing up, 4769 is where the judge gives his direction, or the first of his directions, 4769 to 4770, to keep separate. That is to say, consider each of these cases separate. It's an important direction in the context of this type of case. Now, in my submission, taken in the round, these directions were good enough to ensure that the 10 jurors at least who returned the verdict of guilty did so uninfluenced by the offer, or by the misconduct, rather, of the bribing juror. They would not, in my submission in the light of this, have said, or been subconsciously influenced against them. These couldn't be firmer. That leads me to my fourth point. Was there, looking at the case as a whole, a real risk that the trial was unfair? It's a slightly different question, but it's a global question. I say no. First, I say...
Just before you go there,
Yes, of course.
could I trouble you just to take us to what was said by the judge immediately after the hearing in chambers? You took us to it yesterday, just in terms of page reference.
Forgive me, my lord.
5149.
I'm very grateful.
Yes.
Now,
5149.
5149.
5149 lines 4 to 13.
Yes, thank you.
thank you.
This was after the
Immediately after.
immediately
yes,
after
immediately.
the matter had been raised with the judge.
Yeah. So the jury come back in, so to speak, after the half hour when they've been kept waiting. And this is the first thing the judge says.
Sure.
And that's why we say it's obvious to the jury what he's referring to, because they will know what has happened in the previous half hour.
Are you suggesting that's a targeted direction? It might be said against you. He's just repeating what he said right at the start of the trial. He's had a specific allegation made, and all he's done is to repeat what he said to the jury at the start of the trial.
Well, without adding quite a bit of the stuff he did say at the start of the trial, summing up. That is true, my lord. I fully accept it is not targeted. The question is overall. The overall question is, did the jury, is there a real risk the jury was influenced against the appellants? I submit no. They've got the message from the judge loud and clear all the way through.
Do we see anything in either the judge's appraisal of the problem or in the Court of Appeal's appraisal of the problem of a real weighing of the risk of what I think counsel for the defendants at the time called overcompensation, i.e. a risk that because there'd been a widespread attempt to bribe the jury, then the defendants must be guilty?
My lords, I think it's fair to say there is no... well, the judge himself, obviously, he doesn't, because
He's obviously heard the submission.
decision. Yes, no, he doesn't. No, he just goes ahead. It's a fairly short. The trouble is, it's all dealt with very quickly. It's
And
a
the Court of
short.
Appeal don't seem to address their minds to that issue.
Not quite clear to what extent that was.
As you've shown us at any rate.
One of the problems is in the Court of Appeal, as far as one can tell, that doesn't really appear to be the main thrust of the appeal. The thrust of the appeal was more investigation should be made by the judge. The bias point it was there, but it wasn't, so to speak, centre stage. That's my understanding. And so that, no doubt, is why the matter doesn't receive the attention which now it's been subjected to. But, my lord, the next question is, if I may, was there a real risk that the trial was unfair? I submit that is the ultimate question. That is to say, unfair by reason of subconscious prejudice, conscious prejudice against the accused because of the bribes that had been offered, apparently in their interest. I say there is no real risk that the 10 jurors who voted to convict were influenced to do so by their knowledge that bribes had been offered by the miscreant juror. And first of all, can I just make this point? I submit it as more accurate to describe the question as one of prejudice than as one of bias. The reason I say that is this. Bias generally, in general language, arises as a result of an internal disposition which affects a person's whole way of thinking about a case or about a matter. And this, in my submission, is a heightened, and therefore there's a heightened risk that a juror won't comply with his oath. Supposing I'm an absolute out-and-out racist, I believe all black people are useless or bad. Well, you're never going to get rid of that. The problem is you're very likely, it's just me, it's part of me. Or let us say I'm a Chelsea fan and I'm a referee in a Chelsea game. I'm just going to give all those split decisions to Chelsea and so forth. It's just in me. I can't help it. That's, in my submission, bias which is irremediable. But there's, at the other end of the spectrum, there's prejudice which arises as a result of, or potential prejudice, which arises in the mind of a neutral person or neutral jurors, which comes about as a result of an external event, such as here. Or it could be, let's say in the course of a trial, knowledge of bad character comes out. It's that's the real analogy we have in this case. The jurors have found out something which could weigh against which could cause them to weigh or take things into account against the accused and make him think that he is guilty when otherwise they would not have come to that conclusion. And in my submission, it's that type of case we're dealing with. Was what happened something which is likely, or there's a risk that it caused them to come to a conclusion they would not otherwise have come?
Does it make a difference whether it's bias or prejudice?
It may not, but
the reason what difference it does make at the moment.
But there are some types of prejudice which are more deep, if I can put it this way, insidious. And that would be a racial bias. Than, for instance, I'm a neutral person and I've come to find out something in the course of a trial, and it will be easier, in my submission, for me to forget. And the court can more easily assume that the jury will comply with their oath.
So do we come back to Lord Justice Bingham's, as he then was, test in Putnam, where
Yes.
there's a real risk that, not on this occasion a single juror, but all of the jurors, or one of them, might, as a result of the approach, consciously or unconsciously, have become prejudiced for or against one or more of the defendants?
Yes, I accept that is the test. And that, in fact, the way it's put there is prejudice rather than bias. My lords, I accept that is the test. But, as against that, you have to start from the premise that jurors, you can trust jurors not to be prejudiced and to follow their oath. And I've given you the reference in Bonnet. I won't take you to it now because I'm conscious of time, but also at this point, a similar point arose in the case of Morrison, which you can see at E7560, in particular in paragraph 19. We refer to this in our case, and then 7565, paragraphs 40 to 41, 42 and 44 to 45.
Sorry,
7565, 40, I think, putting it more simply, 40 to 45. And that was the case where, again, the Court of Appeal said, well, you must trust the jury to perform their oath in accordance with their duty. It's a fundamental tenet. Now,
Mr. Knox, I should let you know that we've now received the correct version of the Jury Act, and the version of Section 31 that was enforced then is much simpler, and I think it all makes sense.
I'm sorry it didn't make sense.
Well, it's rather easier to make sense of it.
But I'm grateful, my lord. I haven't yet seen it, but my lord, I'm conscious of the time. Can I just move on to my next point? The first point I'm making is you can trust the jurors. This was a question of prejudice, external prejudice. You can trust the jurors to obey their oath. That's my first point. The second point is this. For the purpose of deciding whether the jurors have complied with their oath, you look at the case as a whole. And especially two things. The overall strength of the case, because that goes to whether they would take any notice at all of the offers of the bribe, and secondly, the actual verdicts they came up with. If I can deal with the second point first, the verdicts. As I mentioned, Shane Williams was acquitted. The evidence against him was less strong. It was simply that he was identified by Chow as one of the men in a video talking about, or appearing to talk about, a killing. The case in which this point is made that you can take into account, or it's a point that matters, is the case of Sander, which is an ECHR case at 7965. I won't take you to it, but it's in the dissenting judgment of Sir Nicholas Bratzer. I think it was 4-3, but he makes the point that the Court of Appeal in England had found it a significant point that there were two Asians, one of whom was acquitted, one of whom was convicted. And that was a significant point in showing that the alleged racial bias didn't actually make much difference, or was unlikely to have made any difference to the jury's thinking. And likewise, I say, by parallel reasoning, here too, the bias, if you've expected the bias at least to be operative, or you would have expected Shane Williams to be convicted as well, but he wasn't. As to the strength of the case, if I can summarise it briefly, just taking one or two passages. Prosecution evidence fell into 5 categories. First, there was Chow's evidence. That is summarised in the Court of Appeal's judgment at 5778 paragraph 9 to 5779 paragraph 12. In short, he goes along with the deceased, he's taken along with the deceased in the car with Campbell at the front, driven along, and then he says, because they're being summoned because the guns have gone missing, and then he witnesses the killing by the 4 appellants at the relevant premises, those premises being owned by Mr. Palmer. After that, he returns and he takes Mr. Palmer to hospital. After that, he is offered, they try to get him, Chow, to leave the country along with them, a few days after. That's the thrust of his evidence. Now, that was obviously evidence subject to a lot of challenge, but the real point about it is it was supported by all the technical evidence. It was supported by the technical evidence, the phone calls and so forth. Well, that was one category. The second category was the deceased's girlfriend's evidence, to the effect that the deceased was never seen after the 16th of August 2011, the inference being he was obviously killed on that day, as Chow said. The third category was the evidence of the police investigations after the killing, and in particular, the entire interior of the house where the killing took place was burnt on the 27th of August, about 2 weeks later. There was a foul odour there on the 29th of August, query what was going on, and then by the 30th of September, the entire rear of the house had been demolished. And that is, you get that at the Court of Appeal's judgment, 5780, paras 14 to 5781, 17. And the appellants were arrested on the 30th of September 2011, and that's 5781, 18. And the point about the burning of the houses is that this was Palmer's house, and there was no report of any damage being done to the house at all by Palmer, and that was a point that was made to the jury. How come, if he owns the house and it's been damaged or burnt down, or burnt at least, how come he makes no report of it at all? The next category of evidence was Exhibit 14C. That consisted of voice and text messages from Palmer, and they are summarised at E5803 to 5807, and they are also summarised in the SFI at E6135, para 10, to 6136, para 13. If I can just ask you briefly to look at the Court of Appeal's summary of that evidence, because it just couldn't be clearer. E5803. A big passage describing Exhibit 14C begins at paragraph 69, and then paragraph 70 describes or summarises the effect of the voice notes. In the original, they're quite difficult to follow because they're all in patois. But you can see if you read 70, paragraph 70 at 5803, on to, if I may ask you just to read yourselves to 5806, the end of 5806, you can see the nature of this evidence. And in particular, you will have seen in passing, 5805, paragraph 73. This is Palmer's text a few days after the event. Between me and you, the recipient's not identified, we chop up de boy lizard, that's the deceased's nickname. Fine, and dashing we enough. As long as you live, dem can never find him. Oh, couldn't be clearer. But the whole picture couldn't be clearer. And then we have also from JS2, I'm just going to give you the references. We have the texts between the deceased and his girlfriend, in particular on the 16th of August 2011. They are summarised at E4788 to 4791. And you can also see a shorter summary at in our written case at 6227.
Can you just give those references again?
Of course.
Yep.
4788.
Yes, thank you.
4791. And in our case, they're summarised again at 6227, paras 40 to 41. But those texts show without a shadow of doubt that the deceased was on his way to be executed, and he suddenly realised what was going to happen to him. There can't be any doubt about that. There are some texts also from Palmer. They were of no significance, but there were texts from Shawn Campbell, which to an extent were incriminating, which suggested that on the day of the killing, but before the killing, Campbell said, who tiefit go dead, that's say whoever stole it is a dead man, and then after the event. But the references, you can see those texts at 4989, lines 1 to 14, and 4990, 13 to 4991. So they're plainly incriminating. Now, the defence cases, and it's important to understand what the defence cases were, they all just gave unsworn statements. Palmer's case was simply that he had never met Lizard at the premises on the day in question. And, my lords, that is at 4341. I should emphasise this. The SFI says that Palmer says he wasn't at the premises. That wasn't actually what he said. He said, I didn't meet Palmer. I never met Lizard at the premises. Rather different. So he doesn't give an alibi. The important point is he doesn't say, oh, I was at a concert or whatever, somewhere in Kingston. No alibi. Campbell, in his unsworn statement, accepted that he drove, he says, ahead of the deceased and Chow in another car to the premises, but he says the deceased got out before getting to those premises. And when Campbell got there, when Campbell got to the premises in question, he says he left Chow there. In other words, Chow did go there, but Campbell says he then left. And later, he saw that Chow, later that evening, he said the only thing Chow mentioned was that Palmer had received a dog bite and had to be taken to hospital. That's 4383 to 4386. Jones's defence was a very short statement. He just said the police were lying about him. That's 6137 at 16, or that's the, I think, of the SFI, and in the record, 4387 to 8. And St John said he left the premises just as Chow entered, and he saw Palmer getting bitten by a dog. And that's 4390 to 4392. But the short point is that there was no denial, as far as one could take out, that they were there. And that is significant because the premises are then subsequently destroyed a few days later, or partly destroyed. And there's no explanation for this. Now, as to the exhibits, X14C, Exhibit 14C and JS2, their cases are simply this. The police have fabricated them. There's just a giant conspiracy to fabricate a whole mass of evidence. And there were challenges to the chain of integrity that went to that. That was it. But there was no explanation as to why the police should have done any of this at all. Now, my lords, bearing all that in mind, we say this was an overwhelming case where, for some reason, the only real question was, were the police in some way motivated, or did they fabricate all this evidence? That was the question for the jury. And, my lords, my lady, I respectfully submit there was nothing to support that. It's difficult to see, therefore, in those circumstances, why the alleged or rather what you might call the bribery, would have made any difference to the consideration of their verdict. And I do submit the strength of a prosecution case in circumstances like this is a material factor. When one was asking, the question is there a risk, a real risk, that the verdict was influenced by prejudice? And I say, no, there's no real risk of that. My lords, my ladies, as far as the jury retirement point is concerned, that's what we say. So we say there was a fair trial, and the fundamental point is you can be satisfied that that 10-1 verdict was a verdict given by the jurors, or the 10, in accordance with their oath, uninfluenced by bias and prejudice. And if that's right, I submit the appeal must be dismissed. The next question I can deal with very briefly is the jury retirement point. My lords, my lady, I submit the following very short points. At the time, that's in 2011, there was no established practice written in a bench book or anything like that. The matter was left to the judge's judgment as to when to send the jury out. Second, I am informed by the Director of Public Prosecutions, who was here, who will provide more detail on the point. In real life, juries never take more than about a couple of hours or so to come up with their verdicts, even after long trials. And it is unheard of for them ever to have to be sequestered in a hotel room overnight. It just doesn't happen. Thirdly, there was, in my submission, no pressure applied by the judge in his directions. This is not a case where there was something the judge said at some point which suggested to the jury, you better get on with it. Far from it. There is at no point anything which the judge says to the effect, I do want you to come back in an hour or so, or please make your minds up, and so forth. So, nothing at all. No criticism of what the judge actually says. And finally, and I submit importantly, the Court of Appeal, who know all about this, how the system works, saw nothing wrong in what had happened. And if I can give you the reference, it's E5854, paragraphs 203 to 205, where they describe, where they go through some of the cases about sending juries out in different jurisdictions, and then again at 209, where they come up with... 5854. Paragraphs 203 to 205, where they discuss the background and various other cases, and 209. And they discuss one or two Privy Council cases where juries have been sent out actually rather later, but although the Privy Council has disapproved of that, nonetheless the convictions were upheld. But in my submission, the Court of Appeal was perfectly entitled to come up with the conclusion they did. No error of law has been identified in anything the Court of Appeal said, and I submit it's not right, it's not the board's place to interfere with the Court of Appeal's judgment on these matters. Very briefly, the proviso, in one sense, my point on the proviso is this. Even if, let us say, the judge's directions after the jury incident were not as strong as they could have been, or should have been, or even if the retirement was too late in the day, there is still no reason to suspect that the jury was infected by bias or the risk of bias, given all the matters I have said. That being so, even if there was some irregularity or some imperfection in the way the trial was conducted, this is a case where there has been no, to use the words of the statute, no substantial miscarriage of justice. I should emphasise that I accept that if there was a risk of bias, a real risk of bias in the verdict, that would mean the trial was unfair, and that would also mean that you couldn't apply the proviso. An unfair trial is written water. But if the trial was fair, in my submission, you apply the proviso.
Do we have the statutory provision that contains the proviso?
I think we do. Yeah. In the bundle. For some reason, I seem to remember reading it recently. If I'm wrong, I'll be corrected. Perhaps I can...
Perhaps you could have the reference later.
I'll give you the references if I can find them. My lords, my lady, that is only one point.
Yes, I think it's page 6806.
Thank you.
I think it's in the standard form of wording you're probably familiar with from other jurisdictions.
Well, I have noticed that they vary on
Well, the one we've been given
That's why I asked.
is the Judicature Appellate Jurisdiction Act, and it's section 14, the proviso to section 14.1.
Thank you.
The no substantial miscarriage of justice test.
Yes.
And that's why I say there is, subject to the unfair trial point, subject to the unfair trial point, there's no unfair trial, the proviso I submit applies. The final question is that of remission. In my submission, this could hardly be a more serious case. It is of particular concern that we are talking here about great celebrities. That doesn't mean that you apply a different standard, but of course it does mean, in my respectful submission, such a high-profile case with, on the face of it, such overwhelming evidence. Most of it, of course, not the entirety of it, being of a technical nature and so forth. I submit this would be an appropriate case for the matter to be remitted for a retrial. My lords, I don't think on the whole you yourselves do that. You normally send it back to the Court of Appeal to consider. But I would submit there's every reason, if I'm wrong, for the Court of Appeal to consider what to do. My lords, those are my submissions on the main point. I've only got a little bit of time on the other points. I think I'm right to say my lords, you have seen our written case.
Yeah, this is the JS2.
Yes, the JS2 point.
Do you want to hear him on it? Or do you want to go off the bench?
Should we rise for a moment?
Yes. Mr. Knox, we'll rise for a moment or two just to consider whether we need to hear you on the JS2 point.
I'm obliged, my lord.